Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut. And today I'm going to talk about the use of what's called a lis pendens in a divorce action. What a lis pendens is, it's a document that you file on the land records of a town where a piece of property is located that basically puts the public on notice that you have a claim to that piece of property. And it's usually filed, in a divorce action if a husband owns a piece of property or a wife owns a piece of property. The opposing party may file a lis pendens on the land records, putting others on notice that they have a claim to the property so that the opposing spouse who owns the property can't go ahead and sell the property. I mean, they could sell the property, but no reasonable buyer is going to buy the property when they see the lis pendens, because if the lis pendens is filed before a potential buyer buys the property, then any claim that the person who filed the lis pendens has to the property would have priority over the buyer. So what it does is prevent people from it prevents any transaction of real estate while a divorce is pending. Now, it's pretty rare that you need to file them. You don't normally need to file a lis pendens because what are called the automatic orders are in place while a divorce is pending. And the automatic orders basically say as soon as a divorce has been signed by a plaintiff or been served on a defendant, once that divorce is pending, neither party is able to do many different things, but one of the things you can't do is you can't buy or sell real estate. You can't make large financial transactions, basically, including buying or selling real estate, unless you have a court order giving you permission to do so, or you have the consent of the other party in writing. So you normally don't need to file lis pendens, but you would essentially if you don't trust the other side. If you say, okay, there are these automatic orders in place, but I don't really think the other person's going to follow those automatic orders. They're likely to violate them. If it's a husband who just doesn't, he's belligerent and says, I don't care what the court says, I'm doing what I want. It can create a lot of headaches if somebody were to sell a piece of property. You'd have to file a motion for contempt, and it can create a whole legal mess that you can generally just prevent if you record a lis pendens on the land records, because he won't be able to sell the property because who's going to buy it? Nobody's going to buy it. Or it can prevent, him from transferring it into his buddy's name, because if you file the lis pendens first, you have, your claim has a higher priority because the lis pendens was filed earlier. So that's, when you would normally want to file a lis pendens is basically if the person on the other side is sketchy and they're not going to follow the automatic court orders. So I'm going to share my screen and show you kind of the logistics of what you do with a lis pendens. If you want to look at the statute that allows it in family court is 46B-80. We don't need to go into the details of the statute, but the actual document, it looks like this, and you'll be able to get this document from our website. But at the top, you just put the name and address of the person that you want the document to be returned to. After it's recorded on the land records, they'll record it and they'll mail the original back to whoever filed it. And then you put the case caption and the title lis pendens, and you just say notices given of the pendency of an action which commenced on so and so a date, wherein plaintiff and defendant, it involves them, and you put the kind of action. Usually it's going to be a dissolution of marriage action, and you're going to include the address of the party of the property that you want the lis pendens recorded for. And then you're obviously going to put the date of it, you're going to sign it, but what you also have to actually do is get a property description for the property, which you can get that from the town clerk. Either there'll be online access for many towns, but you might have to go to the town clerk's office and get the property description. Usually the clerks are pretty helpful. You can just ask them for help obtaining a property description. It's, like it's usually in a Schedule A, and it'll be some technical language that I think is done by like surveyors whenever they first divided up the plot. So you basically document, you draft the lease pendens and you record it on the land records, and then you have to provide notice of the lease pendens to the other side. So you'll give them, you might want to caption this notice of lease pendens, and then you file it and you send a copy to the other side so that they are on notice. And then that should really prevent any problematic transfers of real estate while a divorce is pending. Now, once the divorce is over, you have to remember to file a release of that lease pendens, basically saying, all right, the divorce is over, basically freeing up the property. So here's a sample document that you can, again, pull from our website that shows, what you have to put. You put where in the land records the where the lease pendens was recorded, that the page number, volume number, etc. And that's something you can get from the town clerk. And then you put the date that you're signing it, and again you bring that to the clerk's office and you record it on the land records. So those are the basics of drafting and recording a lease pendens on the land records. It's, you don't normally need to do it, but in certain situations when there's a questionable party on the other side, you might want to do it. And again, if you want to get any of those sample documents, you can pull them from our website. So if you've got any questions, feel free to contact us at any time.